headlines at 9 p.m. on this India development debate. Massive political controversy erupts after the special court acquits all 19 accused, including former Telecom Minister Kanimozhi Raja and DMK leader Kanimozhi in the 2G spectrum case. Big loss of face for the CBI and the Enforcement Directorate. Special Court Judge OP Saini says investigating agencies failed to prove their choreographed charges against any of the accused. Also says there is no concrete evidence of corruption or manipulation of government policies. The Congress moves quickly to grab the political opportunity. Former Prime Minister Manmohan Singh says the so-called scam was nothing but a massive propaganda against his government. Kapil Sibal says former CAG Vinod Rai's presumptive loss theory has been proven wrong and he should apologize. The BJP hits back. FM Arun Jaitley slams the Congress for making the verdict a badge of honour. Senior BJP leader Subramaniam Swamy, however, points finger at top officials in the Finance Ministry for watching up the case. And the government is in a damage control mode. CBI spokesperson says investigating agency will challenge the 2G verdict in the High Court. Enforcement Directorate also says it will knock at the door of the higher court with more evidence. Good evening, it's 9 p.m. on the dot. You're with the India development debate, and straight to the big story we're debating tonight. In a verdict that has sparked a massive political standoff, the special CBI court today acquitted all 19 persons accused in the 2G case, including former Telecom Minister Kanimozhi Raja and DMK leader Kanimozhi. Special Court Judge OP Saini quashed all three cases filed by the CBI and the Enforcement Directorate, saying the investigative agency miserably failed to prove the charges against the accused. The CBI had alleged that Raja advanced the cut-off date for telecom licenses in a bid to benefit a few, and also accused him of colluding with some corporate houses to manipulate the licensing process. The ED, on the other hand, argued that the 200 crore rupee exchange between DB Realty and the DMK-owned Kalangya TV was nothing but a bribe. The DMK camp, of course, broke into celebrations the moment the verdict was pronounced. The Congress too grabbed the political opportunity, saying that the ruling exonerates the UPA government of all charges. The BJP, on the other hand, slammed the Congress for treating the verdict as a badge of honour. We're going to debate the verdict with a whole host of special guests joining us on the show this evening. But before we introduce the panel this evening, I want to put the spotlight on the 5 charges against Kanimozhi Raja and company, because a lot of misrepresentation of facts has happened over the last few weeks. So it's important to talk about what the 5 charges are and not lose the spotlight. First is on the fixation of the cut-off date. The fact that the cut-off date was arbitrarily preponed and the manner in which that was fixed, that is the first charge against A. Raja and company. The second charge, of course, is to do with the manipulation of the first come, first serve criteria for allocating spectrum. Remember, back then, spectrum was not allocated through an auction. A price discovered in the auction that happened in 2001 was taken as the benchmark price and was then given to people on the basis of first come, first serve. Effectively, whoever went to the Department of Telecom with the check first was supposedly getting the auction, was getting spectrum first. So manipulation of the criteria was the second charge. Third charge was to do with allocation of spectrum to dual tech companies. These are essentially CDMA operators who wanted to migrate to GSM services, and the process in which that migration happened was also under investigation. CDMA operators like Reliance Communications and Tata Tele were in the spotlight when it comes to this particular issue. The fourth issue is what got the massive amount of media attention, which had to do with non-revision of entry fee. Like I said, 1,600 crore rupees was the price of the entry fee that was determined through an auction that happened in 2001. That subsequently didn't get revised. CAG subsequently, of course, came out with a report that said had this bandwidth been auctioned, then the government could have discovered a price of up to 1,76,000 crore rupees. So that was a notional value ascribed by the Comptroller and Auditor General of India. That's a debatable value, but that was just one of the criteria that was being examined by the 2G Special Court. And finally, the transfer of 200 crore forced to culling a TV as illegal gratification. Was this the quid pro quo that the ED was trying to establish that Raja gave some of those private companies in response to the allotment of licenses? These are the 5 facts that I want to place before you viewers, on the basis of which today the 2G court has given a clean sheet to all the accused in the 2G scam. Let me introduce the panel without any further delay. And we've got a power-packed panel. Frankly, we couldn't have got a better set of experts on the show this evening. Soli Sorabji, former Attorney General of India; Mahesh Agarwal, advocate, Supreme Court, and he was the counsel for SR, one of the accused in this particular case; Prashant Bhushan, lawyer, activist and politician, and one of the first petitioners in the 2G case that was of course ruled by the Supreme Court of India; Sanjay Jha, representing the Congress party; and Aman Sinha, representing the BJP. Aman Sinha, of course, a lawyer as well. Thank you so much, all of you, for joining us live on the India development debate right here on ET Now. Prashant Bhushan, I'm going to start off with you because in many ways you were the original petitioner in the 2G case that led to the cancellation of 122 licenses by the top court. Earlier today you tweeted that the 2G judgment tells India the judicial system won't hold the influential accountable. Why did you say that?
Yes, because I see it as a appallingly shocking judgment which says that there was no scam, which says that the CBI did not place any evidence, which says that I was waiting for 7 years to somebody to come and place evidence before me. I mean, is this a judge talking or a politician talking? The Supreme Court had itself held, when it cancelled the licenses, that this whole process of allocating licenses was totally arbitrary, totally illegal, and in fact mala fide. It's on that basis that the Supreme Court cancelled the licenses. Now, one of the charges was of criminal misconduct, because if you allocate a valuable resource worth thousands of crores in a totally arbitrary manner without any public interest to benefit a few companies, that's a charge of criminal misconduct even if there is no bribery involved. In this case, you were dealing with public property worth tens of thousands of crores. These were not cinema tickets being given on a first come first served basis. You can't allocate public property worth tens of thousands of crores on a first come first served basis, and thereafter you prepone the last date, giving people only a few hours to bring their drafts of 1600 crores etc. in order to allow your favorite people to get in there first, people who had prior information of that etc. So, the charge of criminal misconduct was clearly made out even on the evidence that was before the Supreme Court.
Okay.
Thereafter, there was the second charge of Benami companies being created.
Right.
Yes.
If I may interrupt you, Prashant, I want to get a quick word from all the panelists. You've made a very compelling first point, and that's probably the basis of the debate we're going to have on the show today. But before I take it to Soli Sorabji and to Mahesh Agarwal, I want to get a quick word from Sanjay Jha. Sanjay Jha, I don't want to make this a political debate, but I have to ask you, what is the Congress celebrating today? I somehow fail to understand, because to the best of my knowledge, the then Prime Minister wrote to the Telecom Minister pointing questions on the manner in which spectrum was being allocated. The then Law Minister H.R. Bharadwaj wrote to the Telecom Minister on the manner seeking a constitution of an empowered group of ministers. The then Finance Secretary D. Subbarao wrote to the Telecom Secretary saying that you cannot give away spectrum at a pittance. So the Congress has, at least on the face of it, I thought, tried to distance itself from the perpetrators of this particular scam. But today, by endorsing Raja, by endorsing Kanimozhi, it's almost as if the Congress party is hand in glove with the entire process of allotment of spectrum in 2008.
Sandeep, that's a ridiculous proposition. Let me just put the facts in perspective at the very outset. First and foremost, it has been established beyond doubt that Vinod Rai's 1,76,000 crores number was an Alice in Wonderland mathematical fantasy. We said it then and we'll say it today, and we stand vindicated. And let me tell you, you can Mr. Prashant Bhushan or anybody can be critical of the court, but for God's sake, today, until it gets contested in the higher courts, you have to accept the verdict as sacrosanct, and you cannot really start casting aspersions on the judge.
I don't
Point
think
number
anyone
one.
is,
Point number
Sanjay
two,
Jha,
and
but go
very
ahead.
fundamental, is that, listen, the GUP, yeah, no. Now, let's get this clear. Let's get this very clear at the very beginning. The second point is very, very fundamental to our discussion, which is that the government of the day, which gets voted in by the people, has to take a call, Sandeep, whether you want your telecom tariff to become a revenue earner, so you want to maximize income for the government, or number two, you're looking at tele-density, you're looking at actually trying to increase the, the usage of mobile, telephony through various services, voice as well as, other value added across to the Aam Janta of India. The government of the UPA took a call that we will try and keep the tariff low, and we will try and ensure that at the end of the day, the usage of mobile should become a greater service for the common man. Now, you can debate about it, but this argument is so flawed that the government should have gone in for an auction, for the simple reason that when you auction, you actually encourage the big capitalists to bid at a higher price, and therefore to that extent the tele-density or the penetration of mobile becomes lower, and people pay a higher tariff. Today, for example, in India, if you have more than 100 crore mobile users, and we are paying such a low tariff, is because of the UPA's policy. Now, one last point, Sandeep, 1 minute. You asked me a question, let me make my one last point. By the way, no, 1 minute, 30 seconds,
Okay,
Sandeep. I usually never take more time than allocated to me. The first come, first served policy, was the one that was introduced by the government of Mr. Vajpayee. We continued with that. And if you read the judgment of the court today, it says that there was no violation of any kind in terms of implementing the same. And if there was a scam in telecom, it happened in 1999 when Mr. Vajpayee was the Prime Minister, and they moved from fixed fee to be paid to the government by the telecom operators.
Okay, you made your point, Sanjay Jha.
That
you made
was
your
the
point,
big
Sanjay
scam that
Jha.
nobody
I just
talks
have one
about.
thing to say. In almost every other
Sure.
channel, I'm sure they're going to debate the CAG's notional loss of 1,76,000 crore. To me, it's a non-issue, because even if there was no notional loss, even assuming that there was no loss made to the exchequer, the manner in which licenses were awarded, that itself is prima facie dubious as per the judgment of the Supreme Court. And I'm going to come to that in a bit. But Aman Sinha, I'm going to let you respond to the point that Sanjay Jha made before I take it to Mr. Suri Sorabji and Mahesh Agarwal. Aman Sinha, quick response to the point made by Sanjay Jha on this whole notional loss theory.
Sandeep, the Supreme Court in its verdict in the 2G case has already categorically held and concluded that the spectrum allocations made by the UPA government were wholly arbitrary, illegal and unconstitutional. Therefore, all 122 licenses issued by the UPA government were cancelled and annulled. Now, what is clear from Mr. Sanjay Jha's argument is that at least he has not read the judgment of special court. Please, will he kindly tell me where in the special court judgment he has mentioned that there was no loss of 1.76 crores, or this is the zero loss theory of Mr. Sibbal has been endorsed? Which paragraph of the judgment? In fact, if at all, the judgment of the special court is a scathing indictment of the kind of botched up investigations which happened during the UPA regime. And all the investigation was completed during the UPA tenure. When you have nothing to say, you can laugh and try to interrupt and subvert the debate. Please allow me to complete and do not interrupt. I did not, although you were saying
Apologize to the people of
incoherent
India.
and incorrect.
Apologize to the
now,
Congress
Sandeep,
party.
Let him complete.
Apologize to
where
what
the
the government was saying.
investigation was
I don't want
Apologize to the
to
people of
hijack this
India.
debate. I need to go to Mr.
No, Aman
Suri
Sinha
Sorabji.
should apologize to the
government
people of
case.
India.
A very
This is
eminent
a
Let him not take a high
where
moral
the
grad
charge sheet
stand
was
today.
Aman Sinha,
filed.
quickly
Stand
complete your
today.
point. I need to go to Mr. Sorabji.
I refuse
Aman
to
Sinha,
Mr.
quickly
stand
Sanjay
complete your
Jha,
point.
when he speaks even incoherent things, people have to sit and listen. And when I'm saying something cogent, he doesn't have the patience to hear me.
Okay, Aman Sinha, quickly complete your point.
The investigations were completed during the UPA tenure. The charge sheet was filed during the UPA tenure. And whatever has come out in the special court judgment is a scathing indictment of the investigation process, the diluted charge sheet which was filed by the UPA government, because they were obviously the ultimate beneficiaries of this. The prosecution also, may I remind, was the same prosecutor who has been continuing. And the question of loss has clearly been established by the Supreme Court. And if Mr. Jha seems to think that the Supreme Court is, the special court is over and above Supreme Court, I have nothing to add there. But subsequently also when the spectrum was allocated during the BJP regime, the spectrum allocation cost was 10 times much higher than the UPA regime.
Aman Sinha, I've given you your time. Aman Sinha, I've given you your time. Sanjay Jha, I don't want to make this a political debate, which is why I've got some eminent members from the legal fraternity. Let me take this to Mr. Soli Sorabji. And Soli Sorabji, this is a very critical point, and I want your opinion on this, because I know this argument has been thrown at us a lot, saying that the Supreme Court only ruled on the process, on the administrative process, and called it arbitrary, did not look at the criminal intent, so-called criminal intent. The 2G trial court looked at it. I want to just read one part of the Supreme Court judgment of 2012 for the benefit of this panel and for the benefit of our viewers. And the Supreme Court in its judgment in 2012 said, February 2012 said, the exercise undertaken by the Department of Telecom under the leadership of the Minister of Communication was wholly arbitrary, capricious and contrary to public interest, apart from being violative of the doctrine of equality. Material produced before court shows that Minister wanted to favor some companies at the cost of the exchequer. Does this not establish criminal intent? Mr. Sorabji.
Well, the Supreme Court may not have said so in so many words, but when they say it's arbitrary, unconstitutional, I suppose criminal intent can be inferred. Mr. Sanjay Jha seems to give no importance to the Supreme Court judgment. Well, let's take it another way. The CBI court has given effect to the principle that the prosecution will prove its charge beyond reasonable doubt. Now, if reasonable doubt was created, we have to see and analyze the judgment. Why? Was it because the prosecution was inefficient? Was it because the prosecution didn't do its job properly? Or because there were certain instances which were not to the notice of the court? Now, the thing is, you can't have a definite opinion at this stage, because all said and done, the matter is likely to go, almost certain to go to the High Court. So though the Raja and others were celebrated, they're entitled to celebrate it, they're feeling very happy about it, but that happiness may be short-lived, because the matter will be examined by the High Court. And the High Court will certainly look into the effect of the Supreme Court judgment. The implication will follow from the judgment, which the CBI court seems to have really not taken into account properly.
You've put the entire issue in context there, Mr. Sorabji. And let me now take it to Mahesh Agarwal there. Of course, he was the counsel of the SR group, but an eminent lawyer himself. Mr. Agarwal, again, I'm quoting from the observation made from the Supreme Court judgment in 2012, which says the manner in which exercise for grant of LOIs to the applicants was conducted on 10/1/2008 leaves no room for doubt that everything was stage managed to favor some companies. As a result, some of the companies which had submitted applications between 2004 and 2006 were pushed down in priority on allotment. I can keep quoting from the judgment, but there seems to be no ambiguity, at least in the Supreme Court order, finding fault in the entire process of allotment. Can we just take refuge in the fact that it only faulted an administrative decision and didn't go into the criminality of these decisions, Mr. Agarwal?
I would put it three ways. Point number one is that we must have some faith in our system. The entire investigation was monitored by the Supreme Court. Regular status reports were filed in the Supreme Court. The special judge was appointed with the consent of the Supreme Court. The prosecutor was appointed by the Supreme Court. Regular reports are being filed in the Supreme Court. So now to say that everybody is shocked or the judgment is absurd is not correct. We should have some faith in the system. The special judge has spent 6 years examining hundreds of witnesses, thousands of documents. Everybody has had a fair trial. There is a judgment now which should be accepted. Now the principal point being made here is that Supreme Court has said that the procedure was arbitrary or the policy was wrong, but Supreme Court never ever decided the prosecution. The Supreme Court left the trial court to decide whether there is a criminality or not. You must remember that on 10 January 2008, 122 licenses were issued. The prosecution was not filed for all 122 licenses. More than about 60 licenses like Videocon and others, there was no criminal case ever filed. So it is wrong to assume that everybody who got license on 122 on 10th January 2008 has done some criminality. The issue, the principal issue before the trial court was whether these companies were eligible or ineligible, and whether to make them eligible some rules have been bent. There was a simple issue of one clause, one guideline, which is absolutely civil in nature. It's a question of interpretation of a guideline. The trial court has observed clearly that DOT did not know what that guideline meant. The MCO, MCA, DOT, government authorities, RBI, nobody was clear as to what is the exact meaning of the guideline.
Okay.
The
okay.
CBI took an interpretation which was completely contrary to the DOT files, to the MCA files.
Okay.
So it's a simple case which was a civil case turned into a criminality.
Okay, fair enough. You made your point, and you spoke about the Supreme Court order. And for the benefit of our viewers, I do want to tell our viewers, in case people are wondering, why did the trial court come up with an order that seems in complete contradiction to the Supreme Court order? It is because the Supreme Court, in its judgment, categorically said that CBI judge should decide on this matter uninfluenced by the Supreme Court judgment. So that's an important point to place in public domain. Sanjay, I'm coming to you, but I want to go to Prashant Bhushan first, which is again on this whole issue of arbitrariness, etc. Mr. Prashant Bhushan, you're a legal expert, but my understanding of Section 13, 1 Clause D, 1D Clause 3 of the Prevention of Corruption Act clearly states that, and I'm not sure the trial court has gone into that in greater detail, that says criminal conduct is proved when you have caused an unfair gain to a private party without gain to the state. And if that is evidently proved as per the Supreme Court judgment, what is the whole brouhaha about?
No, absolutely. That's what I am saying. That the Supreme Court's finding, after examining all the evidence, you see, all the top lawyers of all these companies were there, they stood to lose their licenses worth thousands of crores, etc. And therefore, everything was argued before the Supreme Court threadbare, though it was not a criminal trial being argued before the Supreme Court, but the whole issue of allocation of spectrum and the manner of allocation of spectrum, this first come first served, fiddling with the first come first served, using the 2001 prices to allocate the spectrum, etc. All this was argued threadbare, and after that the Supreme Court came to the conclusion that A, this was arbitrary and mala fide, B, there was no public interest involved, C, it was done to favor a few companies, and D, that there was certainly a grant of huge largesse to these companies. These are all the ingredients which are required to prove a charge of criminal misconduct under 13(1)(d)(3) of the Prevention of Corruption Act. In my view, after these findings by the Supreme Court, for the trial court to hold that no, there was nothing wrong with this manner of giving it on a first come first serve basis, or there was no fiddling with this first come first serve by preponing the dates, etc. There was no favoring of any companies, etc. To my mind, this that's why I am saying that it's an appalling and shocking judgment. The fact that the Supreme Court monitored the investigations only means that the Supreme Court was trying to ensure that the investigations are done properly, and indeed they were done properly, and a very good, very comprehensive charge sheet had been filed, which put together enormous evidence for all these three kinds of charges: the charge of criminal misconduct, the charge of cheating by setting up Benami companies and getting a second license for yourself, as well as the charge of bribery which was made regarding Shahid Balwa's company passing off 200 crores to this Kalignar TV owned by Kanimozhi Raja and the DMK people.
Sure. Okay. Mr. Sorabji, I don't want to make this too technical. Sanjay, I'm coming to you. I know there's politics to be discussed as well, but I want to get this out of the way. Mr. Sorabji, and again, I don't want to make this too technical, but for the benefit of our viewers, we need to understand the substantive issues. The touchstone of criminal misconduct in some ways is Article 14 of the Constitution that guarantees equal opportunity. Again, in light of the Supreme Court judgment, was there equal opportunity for everyone to participate in the 2G spectrum allotment process in 2008? What is your own view of this, Mr. Sorabji?
Where's that charge made out? I think we are not looking at the real thing. I agree with Prashant Bhushan about the Supreme Court judgment, but I don't think an act which is called arbitrary is necessarily criminal. Criminality has to be established by the prosecution needing evidence beyond reasonable doubt.
Right.
So that's one thing I'm not very sure about. And another thing, the matter is bound to go to the High Court. The High Court will have a look at it. So what is all this jubilation, all this happiness and all that? It will be completely short-lived, because one thing is certain, that the Supreme Court judgment and the observations, though they do not necessarily lead to criminality, have been really not given proper effect to by the special judge. And that's a serious flaw in the judgment. But at this point, to determine that, when I have not read the entire judgment, I don't think I'm in a position to say that the judgment is shockingly wrong. It appears to be wrong. It appears to be debatable. And that's what the matter is. So let's see what happens when it goes in appeal before we pass judgment here.
It appears to be debatable without a doubt, which is what we are trying to do here. Obviously, we are no one to comment on the judgment, so to say. At least journalists shouldn't. But Sanjay Jha, I'm coming to you now. You heard there Soli Sorabji saying that celebrations are premature, uncalled for. You've been waiting to make a point. Please go ahead.
Those are individual views. I respect them. I don't have to agree with them. End of day, let's agree to one simple reality, that this was a Supreme Court monitored investigation. The reason being that the Supreme Court left it to the trial court to look at the details of the transactions, investigate if there was any corruption or quid pro quo, if there was a violation of procedure which led to somebody profiteering or somebody benefiting, which created a first among equal situation amongst the various telecom operators bidding for spectrum. Now, what has this judgment said today? I mean, I can read out various sections to you, but I don't want to do that. The simple sum and substance of the response, Sandeep, is that the prosecution, which had, by the way, a very vindictive government against the UPA in Mr. Modi's government, the CBI is, by the way, entirely under their control, now working under Supreme Court investigation, if they have not been able to gather evidence to prove that there was any corruption or quid pro quo, it is a telling commentary that what you saw happening during the time of the allegations made against UPA was nothing but a daylight fraud. I mean, therefore, we have been saying it publicly, and we say it with responsibility, that the Bharatiya Janata Party made political capital. They actually came to power. Narendra Modi is the Prime Minister today. There was an agitation done by activists using this report to say that our government was corrupt. But today, I think we stand vindicated. And let me add one more point. Where is Mr. Vinod Rai? Mr. Vinod Rai was the head of CAG. Sandeep, you will agree with me that a document of the CAG making a comment on the 2G, for example, how did it find its way to the biggest mainstream media? When the responsibility of a constitutional authority was to give it to Parliament. Dr. Manmohan Singh's government was to debate it in Parliament. We never got a chance. The media took a number. It became like the biggest scam, the spectacular scam. 1 minute. And today, Vinod Rai, by the way, is taking sinecures from this government, holds positions. We want to know, we want to investigate the nexus between the BJP and Vinod Rai. Let that be investigated.
Right.
Was that a political conspiracy? Was it an attempt to destabilize the UPA government on clearly fabricated charges?
Okay, Sanjay, I want to place on record here, we're not wasting time debating Vinod Rai's, a 2G report of 1,76,000 crores, because, it's just one aspect of the 2G scam. I know it's a political issue for you and the BJP. I know the BJP reaped a whole lot of political dividend thanks to that figure quoted by Vinod Rai, and I know a lot of experts sort of completely disagree with that, but that's not the subject of debate in entirety, is my limited point. Aman Sinha, but the point that Sanjay Jha made, which is on the prosecution, and again I want to quote from the judgment of Judge OP Saini today, which says that in the beginning the prosecution started the case with great enthusiasm and ardor. However, as the case progressed, it became highly cautious and guarded in its attitude, making it difficult to find out as to what the prosecution really wanted to prove. Who takes the blame for this, Mr. Sinha?
Sandeep, the paragraph that you are reading, and if you read it fully, you would know, who has to take the blame. Obviously, the court observed, special court observed that there was a lot desired from the prosecutor, and they were indifferent at times. This is what the court goes on to observe. And this is what I was mentioning also earlier. Perhaps Mr. Jha is not able to understand for some reason. Let us be very clear. All the investigation was complete before May 2014. So if Mr. Jha is holding the government responsible for botched up investigation, he is making an accusation on the Congress government, not the BJP government. The charge sheet itself was filed before May 2014. So therefore, the investigation was complete, the charge sheet was filed, and whatever was done by the UPA government and on the instructions and directions of the UPA government. Now, based on the fact that perhaps the investigations were botched up and the charge sheet was was diluted and the prosecution could not establish beyond reasonable doubt, the accused were acquitted. And this is what the case is. Any judgment,
Trial
even if
happened,
it is Supreme Court
agreed.
monitored, there could be error in the
Aman
special
Sinha,
court judgment.
3
and
years
there
of the
is.
trial happened
And
when the
therefore it has
NDA
not
was in
attained
power.
finality.
3 years
As
of the
Mr.
trial
Sorabji
happened
was
when the
saying,
NDA was in
this
power.
will-
Your
this will be
government came
subject
to
matter
power
of appeal
promising
before the higher
a
court,
corruption-free
and they will
government.
take a
2G
view on
scam was
this.
one of the key issues on which people voted the Congress out of power. This was an electoral issue, and your government has been in power when 3 years of the trial happened. Surely this government also has to take responsibility for a botched up investigation, for a botched up prosecution. Aman Sinha.
No, Sandeep, the investigation, as I said, was complete.
Agreed.
during the
Investigation
UPA
happened, then
tenure.
what about the
Thereafter,
prosecution,
charge sheet
sir?
was filed during the UPA tenure, and the prosecution was and you have read the relevant para, Sandeep, and if you read it completely, you would know that the prosecutor was appointed by the Supreme Court and it was being monitored by the Supreme Court. Now, when the prosecuting agency goes up in appeal, all these relevant considerations would be there. But obviously, this judgment has not attained finality, as Mr. Sorabji was also saying, and it would be subject matter of appeal. I do not know what the Congress party is celebrating. It was a massive scam. The Supreme Court clearly concludes that this was indeed a massive corruption scam. And if people have been acquitted due to lack of evidence or establishing that beyond reasonable doubt, what is the case for celebrating? I really completely find it incomprehensible why Congress party would celebrate it. So it will all be subject matter of appeal before the appellate court, and they will consider all these facts and all the arguments which were extended and advanced, and all the reasoning which seemed to be on face of it flawed reasoning of the special court, and they will take a view on this.
Okay. Soleh Sorabji, how do you respond to this observation by Judge Saini today in the order, clearly blaming the prosecution for a very shoddy for a very shoddy prosecution? It goes on to say that the prosecution started the case with great enthusiasm and ardor, but as it progressed, it became casual and very lackadaisical in its approach. It says neither the investigator nor the prosecutor was willing to take responsibility for what was said in court. The order also says when final arguments started, the prosecutor did not file written submissions, only oral submissions had to be nudged. I mean, I can just go on and on and on, but it seems to almost indicate that there was no will, there was no desire to get to the bottom of this case.
Well, it seems so. These observations are very disturbing. It shows that prosecution was either inefficient or incapable, or, well, for other reasons, didn't want to do his job properly. But in any case, when the whole evidence is before the appeal court or the high court and appeal it, we examine. All I'm trying to say is certainly celebrate it, but the judgment of the special court is not the judgment of the Supreme Court. It's not the end of the story. It will go further, and thereafter you are celebrating it. If the high court reverses this, what do? You will go in mourning. So keep a balanced view. Don't jump to conclusions merely on the judgment of the special judge and because of some observations made by him about the conduct of the prosecution. But wait till the High Court examines the matter in depth, and then we see what to do, either to celebrate or to mourn.
Mahesh Agarwal has been sort of patiently waiting, and I want him to comment on the debate so far, his observations on all that we've debated. And I want to add a quick question, Mahesh Agarwal, on whether the trial court order, has also ventured into the realm of policy making, because again, if you look at para 17 clause 93, it says the query of finance secretary was not based on sound reasoning. There's another place in para 654, if I'm not wrong, where the judgment says when the law minister called for the case of spectrum allotment to be referred to the EGOM, the opinion of lawmen was malified. Some would argue that this is venturing into the realm of policy making. Mahesh Agarwal, your response to that?
No, I would like to say something else before that. Insofar as prosecution is concerned, just because prosecutor has not been able to prove his case doesn't mean he was incompetent. For 6 years we have faced the trial. They have produced every possible scrap of paper and evidence. The fact is there was no such evidence. Therefore, to show that there was some evidence which the prosecutor has not been able to show is not correct. The impression being given is as if the prosecution is botched up. That's not correct. They have shown every possible government record, every possible government witness has come, but they have not been able to prove the case because there was no such case. Now, insofar as the policy decision is concerned, let us assume, we have to presume that the Supreme Court judgment was correct. It has said arbitrary procedure, etc., etc. But that does not mean criminality. The trial court has also ventured into some issues of policy decision. Now, that is not a court jurisdiction to venture into policy decisions. The policy decision, whether it was right or wrong, the Supreme Court has ruled on it. The jurisdiction of the trial court was only to see whether there is any criminality, was there any criminal intention, has anybody cheated, was there any act of corruption. None of these has been proved. So, we have a situation that Supreme Court judgment stands the way it is, that there was probably an arbitrary procedure, but also the trial court judgment can stand and will stand that there was no corruption.
Okay, you made
and no violation of any particular clause.
Okay, you made a point, and again, for the benefit of our viewers, that you spoke about the fact that it doesn't necessarily mean it was a botched up prosecution. Again, I want to quote just 2 lines from the order today, where judge sort of emotionally says, for the last about 7 years, on all working days, summer vacation included, I religiously sat in the open court from 10 a.m. to 5 p.m. waiting for someone with some legally admissible evidence in his possession, but all in vain. That was, of course, from the judgment of the court today. But Sanjay Jha, I have a few questions to the BJP representative as well, but one point to you, and I know you're looking at this judgment in positive light, but this judgment also reflects very poorly on the Prime Minister's office, because the Congress has always maintained that the Prime Minister was misled by the then Telecom Minister Andimuthu Raja, and that he was not kept in the loop on some of the decisions taken by him. It was also the eventual outcome of the JPC, the Joint Parliamentary Committee, that was set up back then in 2008-9. However, today's judgment categorically states that the PM was not misled by Andimuthu Raja, but by top officials in PMO, including Mr. Pulak Chatterjee. This is in complete contrast with the position taken by the Congress party and by the JPC earlier. Does the buck then stop at PMO for some of these decisions that were taken?
Let me tell you, let's kind of repeat some of the core points that the judgment of the day says today, Sandeep. It says that the kind of allegations that were made, and this is the key point, corruption. And corruption meant that if there was any alteration done in the procedure and the process, which is what the Supreme Court commented on, that there was a contravention of the established process of first come, first served. The truth is, if there was an alteration deemed to be arbitrary or unconstitutional, then clearly somebody had a motive to profit from it. And that's where the criminality element of this court comes into play, which says that there is no evidence at all to prove that there was any minister benefited or anybody else who's apparently alleged to have, been in a corruption deal with the government or the bureaucracy. That has not been established at all. In fact, therefore, the fundamental point is that today when we are talking about that the procedure could have been different. Mr. Raja made certain statements. I think today Mr. Jaitley said that the procedure was tweaked. Well, whatever was done, if you listen to the defense of even the then telecom minister, he said, I was trying to create an atmosphere in the telecom business where there would be new competitors coming in because a couple of monopolists were dominating the entire telecom market. Now, these are views that was taken up by the court. Now, if the court today has agreed after so much of investigation, and this, by the way, is an investigation with a major political repercussion, has been in the public spotlight and has been Supreme Court monitored. Today, when I have people coming on the panel and saying that, you know, this is going to happen in the High Court and Supreme Court, well, how can you assume that the High Court is going to turn this decision down? That's like insulting a certain judge who's gone on record, and I have read parts of the evidence in a summary of the whole, which clearly tell you that the 1,76,000 crores was utter rubbish, that there was a political party that gained.
On where does the
so
buck
far,
stop?
anybody
Did the buck
alleged to
stop
have
at the
been making
PMO?
money has
For
been
the
proven
decisions
wrong.
taken, does the buck stop at the PMO? I asked a very specific question because the same judgment that you're quoting points to the fact that the Prime Minister was not misled
Well,
by Andi Muthuraja but by officials
right.
of the Prime Minister's office.
Well, let me tell you, Dr. Manmohan Singh went on record today to tell you that he was convinced all along that the decisions that were taken, or any decision taken in terms of the spectrum allocation, was done under the larger purview that our government was convinced that natural resources price discovery had to happen, where we were going to give the benefit of the tariff to the common consumer, and the government had no intention to try and treat it as a profit maximization or a revenue maximization model. Now there are interpretations being given that whether Prime Minister Manmohan Singh was that time not given the full facts. Well, the truth of the matter is that the government of the day then adhered to whatever were the established principles of the allocation. Today we stand vindicated. It's for the BJP to explain that for all the charges they made, considering the CBI was under them, why were they not able to establish the corruption allegations they made? And since they have not been able to make it, they should apologize for it to Dr. Manmohan Singh, to the Congress party and to the people of India.
Okay, Aman Sinha, respond to that. I'm going to add another slightly uncomfortable question for you, which is Subramaniam Swamy, your own party's leader and one of the key petitioners in the 2G case that led to the cancellation of 122 licenses along with Prashant Bhushan, today said that, look, there are some people in the party who are to be blamed as they are not serious about the fight against corruption. Arvind Kejriwal has put out a tweet saying that the CBI has messed up the case intentionally. How are we to read this, Aman Sinha?
Yes, I'll come to your second part later on. But first, let me, clarify and say categorically, some attempt has been made to say that the special court judgment says that there has been no corruption, that there were no losses. Now, please, would somebody enlighten exactly which para of the special court judgment says so? Nowhere. In fact, the special court judgment in para 756 to 758 clearly goes on to hold that the procedure was completely flawed. It was implemented in the most shoddy manner. In fact, nothing, no piece of paper as to how the spectrum was allocated was put before the special court, because presumably whatever investigations happened, they could not procure anything as to how the spectrum was allocated. So this is what the fact of matter is. Now, for somebody to say and give themselves gold medal and certificates that this is a finding that there has been no corruption is absolutely astonishing. What is unfortunate is that Supreme Court has clearly
Sandeep, I want to read out the relevant section because Mr. Aman Sinha is misleading your viewers.
Let him finish.
Due to lack of evidence, there has been acquittal. Now, to celebrate this massive case of corruption, an acquittal of accused is remarkable.
Okay.
Now, if I come to the second part of the question,
right.
I do not wish to comment anything on what Mr.
Sandeep,
Subramaniam Swamy has said. He has been making certain allegations against certain individuals. And may I complete, Sandeep, if you want me to?
Please do complete, Mr. Sinha, quickly.
Mr. Swamy has been making certain allegations against certain individuals.
Right.
And that is known. I have nothing to add there. The individual concerned has also responded.
Right.
And as far as, the Attorney General of that time was concerned, he was appearing for the government, may not be in this matter, but he had nothing to do with this matter as long as he was Attorney General.
Okay.
So when he was private counsel, it was a separate issue. So therefore, there is nothing there. However, one must acknowledge and realize that whatever investigations happened during the UPA regime. And if Mr. Sanjay Jha is, indicting the kind of investigations happened, then he has to indict his own Congress government.
Okay. Sanjay Jha, you had to quickly make a point. I need to take a break, and then I've got a few important questions for Mr. Sorabji and for Mr. Agarwal, but quickly, Sanjay Jha.
Yeah. Yeah, I will quote, and this is not my own personal, kind of soundbite. I quote the judgment. There is no evidence of the record produced before the court indicating any criminality or any act allegedly committed by the accused persons relating to fixation of cutoff date, which is what people are alleging even on your panel today, manipulation of first come first served policy, which is what the Supreme Court commented on, allocation of spectrum to dual technology applicants. Just a minute, hear it out, Aman Sinha, don't interrupt me. The charge sheet of the instant case is based mainly on misleading, selective reading, not reading, and out of context. Just a minute, यार चुपचाप रहो जरा सुनो यार और इस सिन्हा जी जरा सुना करो दूसरों को पीछे मत टोको. A recording of the official record. Further, it is based on some oral statements made by the witnesses during investigation.
I take that point.
It is all speculation, rumor, and gossip.
Mr. Sorabji, what are the grounds for challenge of this order? You spoke a couple of times about the fact that it's a given that this will be taken up at a higher court and some of the celebrations are premature. What, I know it's impossible to have read through the entire 1600-page judgment, that's one of the orders, but to your mind, what are the grounds for likely challenge?
Well, the grounds can be that the trial court, the CBI court, has not appreciated the evidence in the proper light, has really based its judgment on conjectures and surmises, and there may be many other grounds. Can anyone be so confident, including Mr. Sanjay Jha, that the High Court in appeal may not take a different view from that taken by the CBI court? Impossible to say that. That would be height of arrogance to say that. We know, in practice, we know very often that what seems to be the trial court judgment seems to be absolutely correct, and people seem to think it will hold its ground even in appeal court. It doesn't happen in appeal court. The appeal court may take an entirely different view of things. So that's what I'm saying. We have to wait till the matter is decided by the High Court and then come to some conclusion if possible. At this stage, to say that it was completely wrong, it was completely manufactured evidence, I think would not be correct. True, arbitrariness does not necessarily mean criminality, but the observations of the Supreme Court are very strong. And the trial court doesn't seem to pay any proper effect, given any effect to them. And that's the main fault of the trial court judgment as far as I can see at this stage.
Sanjay, I'm coming to you, but I want to get Mahesh Agarwal's quick view on the points made there by Mr. Sorabji on the grounds for likely challenge from here on. Mahesh Agarwal.
See, CBI will have to seriously consider the judgment, have a look at the evidence again, and then decide whether to file an appeal or not. For last 6 years, they have made whatever efforts they have. They have not been able to prove a case. There is no evidence to show any criminality. The Supreme Court had a view on the policy decisions of the government at that time. There were two views possible. Supreme Court took a different view. That's correct. But that doesn't mean criminality. For 6 years, CBI has not been able to prove any criminality, and there is no evidence on record. So before the CBI jumps to the conclusion of filing an appeal, they'll have to do some serious thinking about it.
Okay. Sanjay Jha, you want to comment on the point made by Soli Sorabji, because I have got closing comments to get from my panelists. Very quickly, Sanjay Jha.
You know, just a quick response to Mr. Sorabji. By the same token that he assumes that the High Court verdict will go against, I have every right as a citizen of this country to believe that the High Court could remain consistent. So I don't want to comment on that beyond that. The major point that I think, Sandeep, that, you know, as a business channel and as a responsible citizen, not just as a Congress spokesperson, is that these wild allegations, and that's what it stands as of today. We don't know what the High Court or the Supreme Court will do. So let's discuss, live in the moment, and talk about today's judgment. It damaged India's brand equity. It damaged India's reputational capital. We began to be seen as a corrupt nation when we didn't deserve to be, because one political party wanted to exploit it for the lust to become, you know, come in government. And the second point, today, you know, the NPAs in the banking system, today that we discuss on your channel so often, the truth is today many of the big infrastructure and telecom companies bled, and those loans went really bad because of the kind of allegations that were made. And today, I do believe that a lot of the people who were accused have a legitimate right to say that they should, kind of ask the government who's going to compensate them for the loss of business, for the loss of investment, for the loss of market share. I think end of day, India has lost because of the Bharatiya Janata Party's lust for political power.
Sanjay, I take your point on the CAG figure being exaggerated and how media blew it up. I take all that point, but on the point that you made on loss to the government, at the end of the day, all this disruption didn't happen because the BJP made an issue out of it or because Subramaniam filed a case, but because the Supreme Court in its wisdom ruled that the entire process of allotment of license was arbitrary and cancelled 122 licenses, and that was an order by no lower court than the Supreme Court of India. So I think we must not lose sight of that fact, even as this court judgment has come today, which we need to take at face value and acknowledge this. But the fact is that there is a Supreme Court judgment that ruled the entire process as arbitrary and illegal and ordered the cancellation of 122 license. But Aman Sinha, I'm coming to you, and I don't want to get this larger point on damage to the economy. That's a separate debate in itself. But the fact of the matter is, how big an embarrassment, how big a blow is it to the BJP? On the one hand, the issue of botched up prosecution, and more importantly, this whole, because you picked the wrong case as a political narrative, this whole 1,76,000 crore rupees, that was a whole political narrative, which today, to some extent, has been put to rest by the order of Judge Saini.
No, not at all, Sandeep. In fact, time and again I asked that where is the observation in the special court judgment that there was no corruption, and nobody has been able to point it out. The fact of the matter is that apart, the Supreme Court of India has clearly categorically held that the process was entirely unconstitutional, arbitrary and illegal. Therefore, 122 licenses were cancelled, and this has attained finality. Now, why should everyone, people should start questioning it again and again? Do people have not faith in the Supreme Court of India? And what makes Mr. Sanjay Jha laugh and smile if Supreme Court of India has passed the judgment which has attained finality? Just because they have held that this is a clear case of corruption, he seems to be laughing because he has no other answer. Now, as far as please allow me to complete.
Okay.
Even the special court.
I have exactly 2 minutes on the debate. I have exactly 2 minutes.
Now, do not
I have
interrupt
exactly 2 minutes, and I don't want to waste my last 2 minutes in this tutu meme. Aman Sinha, you made your point. I have exactly 2 minutes.
Please allow me to.
Aman Sinha, 10 seconds. I don't want to waste the last 2 minutes in a tutu meme. Aman Sinha, very quickly.
No record has been produced before this court as to how the spectrum was allocated to companies.
Okay.
Please allow me to complete. How can you do that?
Sure.
When
Quickly.
Mr. Jha has been given a free run, please allow me to respond. He has been quoting from the judgment. Let me show what the judgment says. Para 756, and I quote here, no record has been produced before this court as to how the spectrum was allocated to two companies. There is no record as to on which date these companies filed application for allocation of spectrum and on which date the spectrum was actually allocated. As such, as far as these two companies are concerned, so therefore, this is the state of affairs. They had no record, they did not produce anything, and this is the kind of flawed implementation which happened. Therefore, the whole process was absolutely malified, and therefore the Supreme Court has also held it to be unconstitutional, illegal. Now, for people to come around and say that they would not agree with the judgment of Supreme Court is absolutely not tenable.
This
was a massive case of corruption, and I do not know why Congress is celebrating if certain accused have been acquitted.
This celebration, we've had this celebration talk. Very quickly, I'm coming to you, Mahesh Agarwal, and then I'm going to let Mr. Sorabji have the last word in this debate. Mahesh Agarwal, 30 seconds, because one of the counsels of one of the accused came on our channel today and said that they will evaluate the possibility of filing a counter plea seeking refund for the license fees that was paid by them to the government of 1,600 crores. Is there any ground for that at all?
Absolutely. No, absolutely. Please understand, there is a license issued by the government of India. On the strength of that license issued by the government of India, you have foreign companies investing into India. Etisalat, Telenor, Loop, many companies have invested thousands of crores. There were DOT guidelines which said that after grant of license, there have to be rollout obligations. Crores and crores of rupees have been spent to roll out the network, and after that Supreme Court cancelled the license. Now, if it is found there was no criminality, then and the cancellation has been done, each and every company is entitled to a refund. Ultimately, that money is also come either from banks or from some investment. That money has to be returned.
Okay. Mr. Sorabji, does this judgment in a sense
So
open a Pandora's
1,450
box?
crores paid
Okay.
for license fees.
Okay,
It
fair
cannot
enough.
be pocketed by the government, it has to be paid back.
Let me have Mr. Sorabji have the last word on this, gentleman. Does this open a Pandora's box? Because now, like Mr. Agarwal is claiming, some of these accused could then turn out and say, what about the money we've paid as refund? If the process was not criminal, if it was fine, then why don't you give us a refund? But there is a Supreme Court order that called the process arbitrary and cancel licenses. I mean, how are we to read this then, Mr. Sorabji?
Yeah, I think Mr. Mahesh Agarwal is too optimistic. There's no question of refund at this stage. And as I said, no one can be confident that the High Court will not take a different view from the view taken by the CBI court. That's the end of the matter. Let's not unnecessarily speculate whether they can refund or not. Let's wait for the judgment of the High Court. A appeal is bound to be admitted. Whether it be allowed or not is a different matter. But till that time, all these other questions are irrelevant. And one thing I would like to say, any allegation made against Mr. Binod Rai, any aspersions cast on him are totally unwarranted. Totally unwarranted.
Okay. Okay, we'll leave it at that, Mr. Sorabji, Mr. Sanjay Jha, Mr. Aman Sinha, Mr. Mahesh Agarwal. Thank you so much for taking time out and joining us on what really was a fascinating debate here at ET. Now, this has been a judgment that's come in from the 2G trial court by Judge OP Saini. And while one would argue on the merits of that particular case, merits of the judgment, what you cannot take away is the fact that as far as the 2G case is concerned, the order of the Supreme Court, it may have led to disruption, it may have broken the back of the telecom sector, it may have led to job losses, but it changed a few things in this country. It marked a tectonic shift in what constitutes business as usual in the corridors of power. And hopefully those lessons have been learned forever. Thank you so much for being with us on this special edition of the India Development Debate. Good night.